Hi everyone, welcome and thank you for joining us. Today we're having a webinar sponsored by CUNY Citizenship Now and CUNY School of Professional Studies titled Citizenship and Children. Can you go to the next slide, please? I'm going to introduce Paul Russo again, who's going to give you some technical advice.
So, welcome. We're very glad you're here. If you would, throughout the webinar, please do ask your questions. If there's anything that pops in your head, let us know, and we'll ask our presenters to try to cover that at the end. So in order to do that, what you should do is use the blue box at the right side of your screen, the same one you used to let me know that your sound was working. So go ahead and chat your questions in, type them, and we'll get them and pass them on to the presenters. If at any point you run into technical difficulties, please call 800-263-6317. Press 1 and then press 2. So again, that's 800-263-6317. Press 1, then press 2. So thanks a lot and enjoy.
So I want to introduce myself. My name is Patricia Wonder, and I will moderate the webinar today. I'm an instructor at CUNY School of Professional Studies, and I'm also a partner of the law firm Johnson Wonder, PLLC. We could move on, please. We are very fortunate today to have two super qualified presenters. We have Mathilde Roman, who is Deputy Commissioner of the General Counsel's Office of the New York City Mayor's Office of Immigrant Affairs. We also have Maggie Kowinski, who is a staff attorney for CUNY Citizenship Now at the New York City College of Technology Immigration Center. If we can move on. We have two sponsors for the webinars. The first sponsor is CUNY Citizenship Now. For more information on CUNY Citizenship Now, feel free to go to the website, which is www.cuny.edu/citizenshipnow. The other sponsor is CUNY School of Professional Studies. For more information on the School of Professional Studies, please view the website www.sps.cuny.edu. We could move on. I want to tell you a little bit about CUNY SPS. The School of Professional Studies offers an Immigration Law Studies Advanced Graduate Certificate program. The program offers courses such as Introduction to Immigration Law, Business Immigration Law, Family-Based Immigration Law, Proceedings in Immigration Court, and Naturalization. We could move on. For more information on the certificate program, please view the website www.sps.cuny.edu and click on information for the Immigration Law Studies Certificate Program. Continue. The other sponsor today of the webinar is CUNY Citizenship Now. CUNY Citizenship Now offers events to help eligible individuals prepare their N-400 application for naturalization. Most of these events are held on Saturdays. CUNY Citizenship Now has immigration centers all over New York, which offers free immigration services to all members of the community, including CUNY students and non-students. And if you'll see on the left, there's a map of the centers where you could receive immigration assistance. You could continue. CUNY Citizenship Now has a New York City volunteer corps who provide free naturalization application assistance at Citizenship Now events in New York City. You can continue. If you'd like to volunteer with the Citizenship Now Corps, please complete a registration form at www.cuny.edu/citizenshipnow/volunteer. Move on. So now we're going to switch to the substantive portion of our webinar titled Citizenship and Children. Children can obtain U.S. citizenship by a variety of ways, including acquisition, derivation, and citizenship by application. I'm going to turn over to Maggie, who's going to discuss our first topic today. Maggie?
Good afternoon. I'm Maggie Kowinski, and I'll be addressing the acquisition of citizenship portion of the webinar. Now, we all know children born in the United States are born U.S. citizens. In acquisition of citizenship, some children born outside of the United States to a U.S. citizen parent are also born U.S. citizens. They acquire citizenship at birth. Please note, though, an adopted child cannot acquire citizenship at birth. In figuring out whether or not a child acquired citizenship at birth, we'll be using charts in the coming slides. But for right now, let's take a look at the 3 steps of working through an acquisition case. The first step is to find out whether the child was born in wedlock or out of wedlock. Were the parents married to each other on the day of the child's birth? The analysis begins here because the rules are different for each group of children. Now, for the second step, you need to know the child's date of birth. It's the child's date of birth that controls what law is applied. Lastly, knowing the date of birth, you read the chart to see what the residence requirement of the U.S. citizen parent is. There's always a period of time during which the parent must live in the U.S. before the child's birth. Okay, let's move on to the next slide. Here's an excerpt from one of the charts. These charts are available on our website, courtesy of the Immigrant Legal Resource Center. At CUNY Citizenship Now, we routinely use these charts to figure out acquisition cases. Let's work through the chart. As I mentioned before, the acquisition charts are divided into 2 categories, one for children born in wedlock and one for those born out of wedlock. As you see, this chart is for children born in wedlock, on or after November 14, 1986. Now, working from the left to the right, you see the second column concerns the immigration status of the parents, and there are 3 categories. First is for when both parents are U.S. citizens. The second is for when there is one U.S. citizen parent and one national parent. The definition of a national is a person born in or having ties with an outlying possession of the U.S. The outlying possessions are the American Samoa and Swains Island in the South Pacific Ocean. It's very rare to come across a case involving a national parent, mostly because the total population of these islands is about 65,000 people. Okay, on to the third category, for when there is one U.S. citizen parent and one alien parent. The definition of an alien is any non-U.S. citizen, and this includes green card holders. Moving on to the right, the third column concerns the residence requirement of the U.S. citizen parent. Note that your residence is your principal actual home. It's where you sleep at night. And physical presence is the actual time when the parent was physically present in the U.S. This means that any travel outside of the United States, including vacation, must be excluded. Note that if both parents are U.S. citizens on the child's date of birth, just one of the parents need to prove that at some time before the child's birth, they lived in the United States. There is no specific period of time required, like there is if only one parent is a U.S. citizen. Looking at the last column, residence required of child, you notice there is none. This refers to the time period that the child must live in the U.S. after birth to retain their U.S. citizenship, but there are no retention requirements for children born on or after October 10, 1952. If you view the full chart on our website, you'll see the rules before 1952. Before we move on, I'd just like to remind everyone, if you have questions, please send them in. Okay, let's move on to our first poll question. Next slide, please. I'm going to read the question and ask you to submit your answer. John is a U.S. citizen. While vacationing in Jamaica, he met Jane. They fell madly in love and married on January 1, 1996. After John returned to the United States, he petitioned for Jane so that she could receive an immigrant visa, her green card, and moved to the United States to be with him. On September 25, 1996, while she was still in Jamaica waiting for her visa interview, Jane gave birth to a baby girl named Annie. Is Annie a U.S. citizen? As I give you a minute to select your answer, let's review the facts of the case. John and Jane marry on January 1, 1996. Annie is born on September 25, 1996. John is a U.S. citizen. Jane is waiting for her immigrant visa interview. Is Annie a U.S. citizen? And we'll give you another minute to select your answer. If you haven't selected an answer already, please select yes or no to the question of whether or not Annie is a U.S. citizen. So I just wanted to reiterate that at Citizenship Now, we have citizenship events often on Saturdays where we help people apply for naturalization. We have the CUNY Citizenship Corps, which you can register to volunteer and become a part of and help us out at these Saturday events. Okay, folks, I think we're ready to close the poll question. If you haven't answered already, a couple more seconds. Okay, so our poll results are in, and the poll results show that 72% of you said yes, Annie is a U.S. citizen, and you are correct. Let's return to the chart to do the analysis. Next slide, please. Annie was born in wedlock after November 14, 1996. One of her parents, John, was a U.S. citizen, and the other, Jane, was an alien. John must have lived or been physically present in the U.S. or its outlying possessions for 5 years, at least 2 of which were after age 14. If he can prove he did so, and we're going to assume he can, Annie acquired citizenship at birth. Well done, everyone. Okay, let's move on to our next slide. Children born out of wedlock, the other category of children. Let's take a look at the 3 steps of working through an acquisition case for out-of-wedlock children. The first step is to find out whether the mother was a U.S. citizen at the time of the child's birth. In cases where the mother was not a U.S. citizen, the issue of legitimation arises. Legitimation is the process by which the father becomes legally recognized as a parent, and the means of legitimating a child are according to the law of the child's residence. For example, for a child born and living in Guyana, the only way of legitimating that child is for the parents to marry. But in the Dominican Republic, the father only needs to acknowledge the child and register his name onto the child's birth certificate. One way of looking at it is that in order for the child to benefit from the father's U.S. citizenship, the father needs to jump through some hoops, and the hoops are set by the country where the child lives. Okay, let's move on to the next slide. Here we see the chart in instances where the child is born out of wedlock to a U.S. citizen mother. For children born on or after December 24, 1952, the mother needs to have been physically present in the U.S. or its outlying possessions for a continuous period of at least 1 year at some point before the child's birth. Note that any absence breaks the continuity of the period of 365 consecutive days in the United States. Okay, now let's move on to the last acquisition chart slide, which is also the most complex. For a child born out of wedlock on or after November 15, 1971, whose mother was not a U.S. citizen at the time of the child's birth, we need to work through 4 requirements before being able to return to Chart A for final analysis. First, the father-child blood relationship must be established by clear and convincing evidence. Usually, this is done by a DNA test. Second, the father must have been a U.S. citizen at the time of the child's birth. Third, the father, unless of course deceased, must provide a written statement under oath that he will provide financial support for the child until the child reaches 18. And to satisfy the 4th requirement, one of 3 things must happen. 1. While the child is under 18, the child must be legitimated under the law of the child's residence or domicile. Or 2. The father must acknowledge paternity of the child in writing under oath. Or 3. Paternity must be established by a competent court. To help put these acquisition cases in context, understand that many of them are adjudicated at the U.S. consulate in the country where the child was born. The Department of State has a standard form that's used at the consulates. It's called DS-5507, Affidavit of Parentage, Physical Presence, and Support. By submitting this form, 2 requirements can be completed by the father. The 2 requirements are element number 3, the written statement that the father will provide financial support for the child until the child is 18, and one of the options in element number 4, the acknowledgement of paternity in writing under oath. The father attests to both of these in writing to the consulate. And for acquisition cases that are approved by the U.S. consulate, the child is issued a Form FS-240, Consular Report of Birth Abroad of a U.S. citizen. And after that, the child can be issued a U.S. passport. Okay, let's finish with this chart and review requirement 5. In the first, second, and third requirements, and one of the 3 criteria in number 4 are met, you can return to Chart A for final analysis. Chart A, remember, is determining whether children born outside the U.S. in wedlock acquired citizenship at birth. The reason we go back to this chart is because now the out-of-wedlock child shares the same immigration benefits as a child born in wedlock. Before we move on, I'd just like to remind everyone, if you have questions, please send them in. Okay, let's move on to our second poll question. I'm going to read the question and then ask you to submit your answer. Mike, a U.S. citizen, was in Madrid on business in July 2010. During his trip, he met Maria, a citizen of Spain. Mike and Maria shared an unforgettable love affair. In the end, they went their separate ways, and Mike returned to his lifelong home in New York. On March 1, 2011, Maria gave birth to a baby boy named Miguel. Mike flew to Spain the next day. After the DNA tests proved that he is the father, Mike acknowledged Miguel as his son, in writing under oath. Mike's name was put on Miguel's birth certificate. Is Miguel a U.S. citizen? As I give you a minute to select your answer, let's review the facts of the case. Mike is a U.S. citizen. Maria is not, and she is a citizen of Spain. Miguel is born on March 1, 2011. Mike did a DNA test, acknowledged Miguel as his son in writing under oath, and put his name on Miguel's birth certificate. Is Miguel a U.S. citizen? I also would like to mention again the School of Professional Studies and the Immigration Law Certificate program that they have. They also have online classes and classes you can attend in person at the Graduate Center. Please feel free to log into the website, sps.cuny.edu, to check out when the next classes will be beginning. Okay, so hopefully everybody has voted. And the results of the vote are 83% of you said yes, Miguel is a U.S. citizen. Unfortunately, the answer is no, Miguel is not a U.S. citizen. Let's return to the chart to do the analysis. So let's work through the requirements. First, Miguel was born on or after November 15, 1971. Now, starting at the first requirement, first, the blood relationship between Mike and Miguel is established by clear and convincing evidence. Mike did a DNA test. Second, Mike was a U.S. citizen at the time of Miguel's birth. But, third, Mike did not provide a written statement under oath that he will provide financial support for Miguel until he reaches 18. So, unless Mike completes this written statement of financial support for Miguel, Miguel has not acquired citizenship at birth. Okay, folks, now we're going to move on to derivation of citizenship, and I'd like to introduce Matilde Roman, Deputy Commissioner, General Counsel of the New York City Mayor's Office of Immigrant Affairs. Matilde?
Thank you, Maggie. I'm going to cover the next 2 sections of our presentation, which is derivation and citizenship by application. Before I begin, I want to remind our audience to log in their questions so we can respond at the end of our presentation. Let's begin with our discussion on derivative citizenship. Next slide, please. A child born outside the United States may derive U.S. citizenship through the naturalization or U.S. birth of a parent or parents. This is a matter of law. Certain qualifying events must happen before the child turns 18 to derive citizenship. Also note that the law in effect at the time of the last qualifying event takes place is controlling. Next slide, please. The current law that applies to derivation of citizenship is called the Child Citizenship Act of 2001. This law went into effect on February 27, 2001, and it applies to natural-born children and adopted children. However, it does not apply to stepchildren unless the child is legally adopted by the step-parent. And under the law, if a child is born out of wedlock and is not legitimated before the age of 16, the naturalization of the father will not result in the child gaining derivative citizenship. Next slide, please. Under the Child Citizenship Act, a child born outside the United States can automatically become a United States citizen when the following qualifying conditions are met. At least one parent of the child is a U.S. citizen, whether it be by birth or naturalization. The child is under the age of 18 and is unmarried. The child is residing in the United States in the legal and physical custody of the United States citizen parent, and the child is a permanent resident. All of the qualifying events I just mentioned can be fulfilled in any order, but all the events must occur before the child turns 18 years of age. Next slide, please. Let's now turn to a chart that lists the requirements for deriving citizenship. This chart was created by the Immigrant Legal Resource Center, and the complete chart, which is called Chart C, can be found on the CUNY Citizenship Now website. As stated earlier, the Child Citizenship Act went into effect on February 27, 2001, as reflected in the first column that you see there. So any child born on or after February 28, 1983, and meets the qualifying conditions under the current law can derive U.S. citizenship. Let's go over again the requirements under the Child Citizenship Act. First, at least one parent must be a U.S. citizen through birth or naturalization. Second, the child must be a lawful permanent resident and be residing in the United States in the legal and physical custody of the U.S. parent or parents. The child must be under the age of 18 and unmarried. And in the case of a child who was born out of wedlock, the mother must be the one who is or becomes a U.S. citizen, or if the father is a U.S. citizen, then the child must have been legitimated by the father before the child reaches the age of 16. And for adopted children to qualify, the adoption must have occurred before the child's 16th birthday and have been in the legal and physical custody of the adopting parent for at least 2 years. Next slide, please. We've arrived at our next poll question, and I'm going to begin reading. So Renee, her husband Juan, and their daughter Bonita left their home country of Ecuador and immigrated to the United States as permanent residents in 2004. They have been living together in Queens, New York ever since. Last year, Reina applied for naturalization. Her application was approved on April 15, 2010. She was sworn in as a U.S. citizen on May 15, 2010. And Bonita's date of birth is May 1, 1992. Has Bonita derived U.S. citizenship? So let's take a moment for you to answer the question. And while we wait, I'll reread the question one more time. So Renee, her husband Juan, and their daughter Bonita left their home country of Ecuador and immigrated to the United States as permanent residents in 2004. They have been living together in Queens, New York ever since. Last year, Reina applied for naturalization. Her application was approved on April 15, 2010. She was sworn in as a U.S. citizen on May 15, 2010. And Bonita's date of birth is May 1, 1992. So is Bonita a citizen based on derivation? So while we wait for the poll questions, I want to reiterate that you have an opportunity to pose your questions so that we're able to answer them in the order that they come in at the end of this presentation. And let's go to the results. So based on your responses, 62% stated that Bonita had derived U.S. citizenship based on her mother's naturalization. So if you look at, if we turn to the slide, the chart C, Regrettably, the answer, and from the most who said no, were correct. Based on the fact pattern, Bonita could not derive citizenship from her mother. Reina's application for citizenship was approved on April 15, 2010, but she wasn't sworn in as a U.S. citizen until May 15th, which that means that Bonita was already 18 years of age. Her birthday was May 1st, 2010. She would have been turned 18. So that means 14 days after Bonita turned 18, her mother became a U.S. citizen. Remember, all the qualifying conditions must be met before the child's 18th birthday in order to derive citizenship. The last qualifying event was Bonita's mother's U.S. citizenship, and that occurred 14 days after she turned 18. So what options does Bonita have at this point? Her option is to apply for naturalization and file an M-400 because she is 18, she is a lawful permanent resident, and if she meets all the other qualifying conditions and criteria for naturalization, she can apply and within 3 to 4 months become a citizen of this country through the naturalization process. So let's move on. Next slide, please. So there were other laws in effect prior to the enactment of the Child Citizenship Act. These laws had different criteria for how children could derive U.S. citizenship. And so let's briefly go over the law prior to the Child Citizenship Act so that we can see the distinctions. Previous law states that for a child to derive citizenship, both parents must have naturalized or been U.S. citizens while the permanent resident child was under 18 and unmarried. There were exceptions that applied when the child's other parent was deceased or when the child's parents were divorced or separated and the naturalized parent had legal custody of the child following divorce or separation. Under prior law, children born out of wedlock qualify if the child was not legitimated before the age of 16, and it is the mother who naturalizes. Next slide, please. So children who derive citizenship can apply for a certificate of citizenship through the U.S. Citizenship and Immigration Service. To apply for the certificate, one must complete Form N-600. This form can be filed by any person claiming to have acquired U.S. citizenship. In case of children who derive citizenship who are under the age of 18, the application must be filed by a U.S. citizen parent or legal guardian having legal and physical custody over that child. Form N-600 is available on the U.S. Citizenship and Immigration Services website, which is www.uscis.gov. You can also get the form by calling the USCIS Forms Request Line, which is 1-800-870-3676. Next slide, please. So the filing fee for the N-600 is $600. If filing on behalf of an adopted minor child pursuant to Section 320 of the Immigration and Nationality Act, the fee is reduced to $550. There is no fee when filed by a member or veteran of any branch of the U.S. Armed Forces. The N-600 application is mailed to the USCIS field offices having jurisdiction over the applicant's place of residence. Next slide. Thank you. So there are some practitioners who tell individuals who derive citizenship to apply for a U.S. passport instead of acquiring a certificate of citizenship. A person who derives citizenship can apply for a U.S. passport directly without first obtaining a certificate of citizenship. However, the certificate of citizenship is still the best evidence demonstrating U.S. citizenship. So if a person chooses to obtain or apply for a U.S. passport, an individual must complete and submit a Form DS-11 in person at any acceptance facility. An example of that would be the U.S. Post Office or a passport agency, and bring with them all original documents that are required. The applicants are processed by the U.S. State Department, these applications for U.S. passports, based on the paperwork submitted. There are a few key distinctions between applying for a U.S. passport and a certificate of citizenship that I want you to be made aware of. For one, there is no interview when one applies for a U.S. passport, but there is an interview before the U.S. Citizenship and Immigration Services for those who apply for a certificate of citizenship. There is an appeal process for denials of an N-600 application. This is not the case if your application for a U.S. passport is rejected. Another difference is the cost. The filing fee for a U.S. passport is $105 for those under the age of 16 and $135 for those 16 and older. The filing fee for the N-600 application is $600. Lastly, the average processing times differ greatly. For a U.S. passport, the wait time is 4 to 6 weeks. The average wait time for a certificate of citizenship is 4 to 6 months. Next slide, please. So, citizenship by application is another way children obtain U.S. citizenship. It is rarely used, but worth briefly reviewing so that you are well aware of all the variety of ways in which a child can acquire citizenship. Children legally in the United States, but not as a permanent resident, who meet certain requirements can obtain U.S. citizenship. To qualify, all the following must be true. One parent must be a U.S. citizen. The child must be under the age of 18. The child must be temporarily present in the United States after a lawful admission and is maintaining lawful status. The child must also be residing outside the United States in the legal and physical custody of the U.S. citizen parent. And the U.S. citizen custodial parent has to have been physically present in the United States for 5 years, 2 of which were after his or her 14th birthday. Next slide, please. For adopted children, the adoption must have occurred prior to the child's 16th birthday, and the child must meet all the requirements for an adopted child or orphan. If the U.S. citizen parent hasn't met the physical presence requirements of having been physically present in the United States for 5 years, 2 of which were after his or her 14th birthday, the child may still obtain citizenship through a U.S. grandparent if that grandparent can meet the physical presence requirement. Next slide, please. So now we've reached the point where we're at our final poll question, and I'm going to read it to you. Juan was born in Peru in 1995. He was raised by his Peruvian mother and father until 2000, when his father's employer moved him to the United States. Even though they separated, his parents remained legally married. Juan's father worked in the United States for several years, and his job sponsored him for his green card. Eventually, Juan's father naturalized in the United States, and in 2008, he returned to Juan and his mother in Peru. Juan wanted to study in the United States, and so he went to New York City in July 2010 on a visitor's visa to visit colleges. He was given 6 months to stay in the U.S. His father accompanied him on the trip. Can Juan obtain citizenship by application? So I'll give everyone a few minutes to answer the question. And I want to take a moment to talk to you about the wonderful program that CUNY offers, which is at the School of Professional Studies, is an immigration certificate program that leads after consecutive periods of you attending certain key courses, a certificate, and it really provides the fundamental of immigration law. They have the intro course and they have the business courses, and I highly recommend anybody who's interested in really understanding immigration law, as it's such a complex and difficult area of law, to really avail themselves an opportunity of attending these certificate courses, because they're really an asset to the city. And let's move on to the poll results. So, can Juan obtain citizenship by application? And the vast majority of you said yes. 61% of you polled said yes, and you are correct. Based on the facts, Juan's father would be able to do an application for citizenship for him. Juan was born in 1995. He was under 18 when he was lawfully admitted into the United States and was maintaining lawful status while temporarily present. Remember, he came in as a visitor for 6 months. So he came in July of 2010 and was able to remain here until January 2011. And the type of activity that he was coming to do, which is kind of see colleges under the B1, B2 category, he was able and permissible activity, and so he was maintaining lawful status. His father was a United States citizen, And then since 2008, Huang was residing outside of the United States in the legal and physical custody of his United States citizen father and his mother. Remember, his father returned in 2008 to be reunited with his family. Lastly, it appears that Huang's father can establish the physical presence requirement given the number of years he was residing in the United States based on his employment. So next slide, please. So congratulations to all of you who responded correctly to that poll question. Want to quickly tell you in order for a person to apply under this application for citizenship, you can use filing of the N600K application for citizenship and issuance of a certificate under Section 322 of the Immigration and Nationality Act. The U.S. citizen parent must file on behalf of the minor adopted or biological child. If the U.S. citizen is deceased, the U.S. citizen grandparent or legal guardian can file the application, and the child need not be residing in the legal and physical custody of the grandparent or legal guardian in order for this application to be made. Next slide, please. And so the N600K form can be obtained through the USCIS website or by calling the USCIS forms request line. And the number and the website address are listed in the deck. The filing fee is $600, and applications need to be mailed to the USCIS field office with jurisdiction over the applicant's place of residence. And so this concludes my portion of the presentation. I urge you all, if you haven't done so, to please pose your questions so that we can be able to answer them. And now it's time to turn it over to the moderator and begin our question and answer session. Thank you very much.
Thanks, Matilde. So I just want to tell everyone that we're just going to give you another minute or two to ask any last-minute questions, but we're actually going to close that very shortly. We received a lot of questions, and we're going to focus on questions that are related to the topic. If you do have questions that are not related to the topic, you're more than welcome to email me. My email will be given at the end, or also go to one of the Citizenship Now immigration centers for further advice. I'm going to turn it over to Maggie, who's going to read our first question from the audience, and we'll have a discussion of the answer. Maggie?
Okay, so the first question we had says, Canadian born in Canada to two U.S. citizen parents. U.S. citizen parents resided in Canada a few months each year. I assume that also the other months of the year the U.S. citizen parents lived in the United States. And the question is, can the child derive citizenship? And the child was born on February 3rd, 1956. Now, this is not a derivation question. This is an acquisition of citizenship question. Because at the time the child's born, the two parents are already U.S. citizens. And yes, at the time the kid was born, he did acquire U.S. citizenship, regardless of whether or not the kid was born in wedlock or out of wedlock. And if we just look at the charts, if the child's born in wedlock after, let's get the dates here. So the child was born in 1956, and the rule in 1956 is that if both parents are U.S. citizens on the date of birth, only one parent had to reside in the U.S. at some point before he was born, or she. And in the question we see that the parents were both residing sometimes in the U.S., sometimes in Canada. So if he's born in wedlock, yes. If out of wedlock, just the mother has to be the U.S. citizen on the date of birth and has to have lived in the U.S. at some point before the child's birth for 1 year. If the U.S. citizen mother lived in the U.S. for 1 year, yes, also acquired citizenship in this case. But remember, you just have to revert back to the acquisition charts. And again, the most important question was, when's the date of birth, and was the child born in wedlock or out of wedlock? And you take it from there.
Thanks, Maggie. I just want to add to that point, citizenship and children issues are very complicated. So as we are going by the question that you asked, we don't have specific facts such as how long the parents have lived in the country and other facts that are really important to determine an accurate answer. So we did the best we could based on the facts provided the charts are very important, but we would always recommend that you seek out some professional assistance because citizenship and children questions are very difficult. So we're going to move on, and Matilda is going to read our second question.
So the second question is, what would an individual need to show at an interview to acquire citizenship? So if the individual who filed the N-600 form is asked to appear for an interview, that individual must bring a photo ID, originals of the copies they mailed in with the N-600 application, which would be documents to show relationships, identity documents, so whatever was required based on their particular facts, they would have to bring originals of those documents. And the originals would, and then the individual would be asked at the time of the interview several key questions regarding their status or their residence or their parents and their past residence in the United States. So that's pretty much in response to this question, what somebody would need to bring to acquire citizenship in their interview process.
Thank you, Matilda. I just want to remind everyone that, often when you file with immigration, you submit copies. So it's important to bring, as Matilda said, the originals with you to the interview because immigration wants to authenticate those documents. Really what immigration is looking for is showing the relationship between the petitioner and the applicant. So you want to have those identity documents, and you also want to have the documents which show that you meet all the requirements for the category that you're filing for citizenship. So if you have to show a period of residency, you'll have to have documents to show that. If you're trying to show that a parent legally adopted you, then you'll have to have an adoption certificate. So the evidence that you'll need to submit, again, will be really fact sensitive. So it's important that you go over which category you're filing under and you make sure you hit every requirement to submit the pertinent documents for that category. So now we're going to switch over to Matilda, who's going to, to Maggie, who's going to go over our third question.
Okay, the third question asks, if U.S. state law permits the father to legitimate the child, why may child not qualify as a legitimate child under U.S. immigration law? The answer is that if the child is not residing in the state at the time of legitimation, the legitimation is not recognized by U.S. immigration law. Remember, the legitimation must take place while the child is under 18 in the place where the child is residing. So if the child is legitimated here in New York State and the child is residing with the father in New York State, then yes, U.S. immigration law will recognize the legitimation. But if the child is residing abroad and the father does it here, it will not be recognized by U.S. immigration law.
Thanks, Maggie. So this may seem really daunting and inconvenient for people because the question was framed around if the U.S. State law recognizes the child's been legitimized, why doesn't U.S. immigration law just go by that? And U.S. immigration law needs to review what the requirements are for the residency of the child's home country because it's impossible for U.S. immigration law to know every requirement of every country. So they must look to that, and that's just the law that U.S. must follow. So it's important to always recognize that, to review what the requirements are for the child's place of residency and determine whether or not that child has been legitimized. That's what's important. So now we're going to move on to Matilda, who's going to go over our fourth question.
So the fourth question is, can a child of unlawful immigrants who came to the United States with their parents obtain U.S. citizenship? And that depends on whether the child was born in or out of wedlock, and whether the child's other parent is a U.S. citizen and the child is able to claim acquisition or derivation through that U.S. citizenship, that USC parent.
I mean, this is an unfortunate situation because if both parents happen to have come here without any lawful status, so if they came here without a visa or they came with a visa and then they overstayed and they're not U.S. citizens, if one or both, then unfortunately this child's not going to be able to derive or acquire citizenship from those parents. So that child's going to have to look to other ways to try and make themselves in a lawful immigrant status, and then lead the way to citizenship. But unless, again, one of the parents is a U.S. citizen, it doesn't seem likely in this case. So we're going to move on to our next question, who is Maggie.
Okay, so question number 5 is asking, to clarify step-parents and children obtaining U.S. citizenship through step-parents. Just to be clear, you cannot derive or acquire U.S. citizenship through a step-parent. The only exception is if the step-parent has legally adopted you and other requirements are met. Looking at Chart C for derivative citizenship that we have on the website, courtesy of Immigrant Legal Resource Center, you see that after Child Citizenship Act, so after February 27, 2001, an adopted child can derive citizenship if certain conditions are met. So the requirement is that the child was adopted before age 16 and has been in the legal custody of and has residing with the adoptive parent for at least 2 years. So if these conditions are met, then yes, an adopted child could derive citizenship through their parent who used to be their step-parent.
Thank you, Maggie. And the last and final question, we're going to go to Matilde.
Okay. So the question is, the U.S. citizen has a son who, after DNA tests, determined not his biological son. If the U.S. citizen person adopts the son, can the son obtain U.S. citizenship? And so for acquisition cases, the answer is no. For derivation, it is also no, even though under the Child Citizenship Act, adopted children can also derive citizenship. In this case, the child cannot, because for adopted children wanting to derive, the child must be in the United States at the time of the citizen parent's naturalization. And here it seems that the father is already a U.S. citizen before the adoption, and so the answer to that is no.
Thank you, Matilde. I just want to turn over to Maggie really quick, who's just going to give you some useful resource if you have further questions on this topic.
So a very common question is, how do I find out what the legitimation law is of the country? And just to give you 2 ideas, one, there's a very useful book published by Charles Roth and Daniel Levy called U.S. Citizenship and Naturalization Handbook. The most recent edition is 2009 to 2010. It has a list in there according to country, and many countries are in there, but not all, and also all the states in the United States explaining what the legitimation law is for each jurisdiction. If the country doesn't happen to be in the Levy's book, contact the consulate of the country and see if you can talk to somebody. Email them, call them. Folks are surprisingly helpful. You could also just call the registry court or office in the country where you're having the issue. I was on the phone with somebody in the Grenada registry a couple weeks ago. Very helpful and understanding of these types of cases and how difficult it is to get the information you need to help people over here.
Thanks, Maggie. I just also want to give you another resource, and we've mentioned the SPS program before. The certificate program does have an introduction to immigration law class, which goes over many topics. So it's an overview of immigration studies, such as asylum and employment-based visas, family-based visas. There is, I teach the introduction to immigration law class, and we do spend 2 weeks on naturalization and citizenship issues. But also in the certificate program, there's a whole course that's just about citizenship issues. So if this is something that you would like more information on, feel free to check out SPS's website and get more information on their certificate program. So we're concluding our question and answer session. We can move to our next slide. We want to thank everyone for giving in their questions, and I hope the answers were helpful. And I want to thank again our wonderful panel of presenters who did a fabulous job explaining Citizenship and Children, Matilde Roman and Maggie Kowinski. So this question actually came up during the presentation about whether or not the seminar will be recorded. Yes, it will be recorded, and after the seminar you'll receive an email with instructions on how to access this web seminar, and related materials will be sent to you shortly. And just so that you know that this webinar series is a monthly webinar series. So it's important to sign up because even if you're not sure if you're going to be able to attend, if you do sign up, that email will automatically be generated to you after the webinar. We can move to the next slide. The people that are listed here, we just want to acknowledge and thank for all their help and assistance and hard work with this webinar series. We can move to the next slide. So we've tried over this hour or so to go over a very difficult topic and make it as concise and easy for you to understand as possible. But it's impossible to answer all the questions that you have. If you feel that something's been unanswered, or if you have further questions, feel free to contact me, Patricia Wonder at johnsonwonder.com. You can move to the next slide. So I just wanted to, there's no more slides, I wanted to thank everyone again for joining us. I do want to remind you that this is just one of a monthly webinar series that we will be having moving forward. Please look out for the invitation for our January webinar, which will be on winning a marriage case. So we're going to be leaving the naturalization topic. And we look forward to having you at the next webinar, and thank you so much for joining us today.